Hello, I'm David DeLugas, the $99 lawyer. Each Thursday, I will take one of the questions posted on our Facebook page and answer it, trying to do so in a manner that will make it as usable for as many of you as possible. Now, each week, please post your question, and perhaps next week I'll be responding to it. Now, this week's question is, what is an evidentiary hearing, and what is a hearing, and can that hearing be used in family court? Now, the way I'm going to answer that question, and please read the disclaimer that comes at the end of this response, but the way I'm going to frame that question is, what is the difference between a hearing with regard to any motions, and what are evidentiary hearings or trials, and can they be used, and when can they be used? Now, here's my answer. When there are factual issues that are necessary to be resolved in order for the trial judge to make a decision or to impose terms and conditions, then there must be evidence. And there are only two ways evidence gets in front of a judge and gets admitted. One is the testimony under oath of a witness. And secondly, documents, photographs, other tangible items that are admitted into evidence after the proper foundation, and that's a word that you need to be familiar with, after a proper foundation is laid. Now, affidavits sometimes in some courts, in some proceedings, in some states are admissible into evidence. Generally, at any final trial or hearing, affidavits are of no use at all. You must have a witness. So, first determine what kind of issue is being presented. If it's a motion that does not involve facts, but it's a motion based on, say, a motion to dismiss, or a motion for judgment on the pleadings, or another motion that is entirely based upon legal principles or the law or Court of Appeals decisions, in those cases, procedural motions, for example, in those cases, there will be a hearing at which argument can be presented and citations of authority to law, Court of Appeals decisions, and the like can be presented to the judge in some manner that tries to convince the judge that your position is correct. Now, obviously, opposing party, with or without an attorney, is going to try to argue that their position is correct. So, you need to be prepared. Now, if it is a hearing at which evidence is going to be introduced because there's some facts in dispute, and this applies to business types of disputes, contract cases, employer-employee cases, yes, anything to do with divorce, custody, modification, contempt. There have to be facts determined by the judge or a jury. Then evidence has to be introduced, meaning presented under oath by a live witness. Sometimes you can use a deposition, which is the recording of witnesses testifying under oath prior to the hearing or trial. If you need to have a witness there, go to the court clerk, get a subpoena issued. Often they're either free or just $1 to have it issued. Then you have to fill it out properly, make sure there's a witness fee that is appropriate for your case in your area, and serve that. And there are different ways you can serve officially. In some cases, in some states, you can serve through certified mail return receipt requested, but not all states allow that. In other states, the sheriff has to serve. Some states, a private processor can be used, and in some situations, the private processor has to be approved by the local court. So you'll just have to research that and make a determination of how you would accomplish this task. Now, if there's an evidentiary hearing, you may testify if you know the facts. And when you testify, you can only testify to what you know from personal observation, what you heard, what you saw, what you read. Now, you may have heard the term hearsay. What you heard someone else say generally is not admissible unless the person who is the other person you heard say it is your opponent or someone who works for your opponent. That would be called an admission against interest. So there are certain rules that govern what evidence can and cannot be admitted. Now, one of the important things about documents, photographs, tape recordings, if they're allowed by law in your state, and let's say tangible items, you have some physical item that you're bringing to show the court. For it to be admitted into evidence, you have to actually say, Judge, I move to admit exhibit number 5 into evidence. And you will have put a little sticker on it, marked it as number 5, identified it through testimony under oath by you or one of your witnesses. And you will say, well, this is an email I received from Miss Jones or from XYZ Company on the 25th of December 2012. And you're thinking, why did I get it on Christmas Day? Not sure why I used that date. In any event, you must identify the document, describe what's in it from your personal knowledge, and indicate what it is, and in some fashion make sure the court knows. Then the opposing party or their attorney will have an opportunity to object as to why you have not laid a proper foundation, or why the document, photograph, or other tangible item is not relevant to the factual issue that is before the court. And then the judge will make some ruling on it. When other parties or the other lawyer is talking, please don't interrupt. Judges get very upset with people who seem to be unprofessional, which you may be because you're not a lawyer, and interrupt the opposing party or their lawyer. But you will then again have an opportunity to address the court if there's an objection made, for example. The court will turn to you and say, well, what do you say? Meaning, what do you say in response to what the objection was just made? And then the judge will make a ruling saying, I sustain the objection. Sustain means I agree with the objection, in which case your piece of evidence is not going to be admitted. Or I overrule the objection, meaning I don't agree with the objection, and your piece of evidence will be admitted. So that's how you would get tangible evidence in. Let me give you one more piece of evidentiary rule of law that may be helpful. If you're testifying about the value of something, the value of your house, the value of your car, the car that was damaged in a wreck, the value of something that was damaged by somebody and you're suing them over it, or you're in a divorce case and you're dealing with the property you and your spouse owns, you may testify as to the fair market value of that item. And that's because you're one of the owners of it, and that's permissible in most jurisdictions. When you do that, please don't make reference to where you found out or how you found out what the value of it is. Simply say, it is my opinion that the value of the automobile is $7,800, and stop. Now, clearly you must have done some research and found that valuation in some form or fashion, but the source of your information is just the basis on which you've come to your conclusion and opinion as to value, and the opposing party may cross-examine you to determine whether or not you should be believed. But if you say, well, I talked to Joe the mechanic and I went to a used car lot and the car manager told me my car was worth $7,800, so that's why I think it's worth $7,800, that is hearsay because the car manager is not there testifying. You're safer to bring somebody in, qualify them as an expert witness, and let them testify as to valuations, and that would include an appraisal. If you had an appraiser for real estate who's certified in your jurisdiction to do appraisals, you pay them their $200, $400, $500 fee. They give you appraisal for your home and the land. It may or may not be admissible where you are. It'll be a waste, and that appraiser is not in the courtroom under oath testifying. That appraisal, the document, may not be admitted into evidence. So you need to have all those things lined up, and I'd be happy to help you with those items and make sure you're prepared. The most important thing about going to a hearing is A, understand what the hearing is for. Why are you there? What's going to be addressed? B, be sure you're prepared to respond, or you're prepared, if it's your motion or your hearing, you're prepared to present evidence, and you're prepared to make the legal arguments that may be necessary in your case. This can be done by quite a few people. Yes, it's great if you can and have an attorney and you can afford an attorney, and I hope you do and get a good one. But if you simply cannot, or you've made the decision that you're going to do it on your own, look for help everywhere you can, including me, the $99 lawyer. Now, thank you for watching, and I hope this has been helpful to you.